Hello everyone, welcome to Court with Krissy. Here are 3 fun ones I know you'll love. First up, grab the tissues, we've got a couple of criers. And then ending with the pro se who has not only an inaffordable bond, but a plea deal to consider. Decisions, decisions. What will he do? I hope you like it. Court with Krissy is now in session.
All right, your name and jail, please.
David Reed.
Mr. Reed, this is a felony file 251050FY. I'm going to read it to you.
Good afternoon, Assistant Public Defender Darius here, appearing on behalf of Mr. Reed for the limited purpose of arraignment. This felony file will be time. He must screen for court. He's asking that this matter is set for probable cause conference and preliminary examination. He will screen for court-appointed attorney, and that has been granted.
Okay. So, sir, you will have the public defender as your attorney for the remainder of this case. Your bond in this case was set in the amount of $5,000 as cash or surety. That is also a protective condition of bond, meaning you cannot have any contact, direct or indirect, with one Randall Reed. You cannot go where that person lives or where they work. You cannot consume alcohol or any other controlled substances. You cannot possess a firearm or any other dangerous weapon. You cannot leave the state of Michigan without permission from the court. Do you understand and agree to those rules?
Yes, Your Honor.
Mr. Sierra, do you wish to be heard on bond?
I do, Your Honor. Thank you. In this specific circumstance, Your Honor, Mr. Reed has indicated and has provided the court an address where he can live that is not with the named complainant in this matter. Mr. Reed has shown a willingness to appear for court. As such, he was in court just recently without any issues. He currently can't afford a small amount for bond purposes, but given the fact that he has shown he can appear for court, I believe he is no threat or no flight risk, and I'd ask the court to release him on his own cognizance.
You have felony domestic violence charge from 1 month before this.
Yeah, my dad was drunk that night too, and but that time the
I'm going to leave this in place for now. I'm going to give the prosecutors a chance to weigh in on what happened there. You already have next court dates. You have a probable cause conference on April 10. You have a preliminary hearing on April 15. That's courtroom B in front of Judge Belargin. You will get copies of those dates and times. You must show up for those dates and times. You're all set.
It's a false report, Your Honor. He done a false report. This can't be right.
Hello, Your Honor.
Good afternoon. Your name?
Brenda Shrout. Did you hear me? Brenda Shrout.
Yep. Ma'am, this is a felony file 250972FY. I'm going to read it to you.
Good afternoon, Assistant Public Defender Darius here, appearing on behalf of Ms. Shrout for the limited purpose of arraignment. We have reviewed the charge people reading at this time. She's asking that it is set for probable cause and prelim. She was screened for court-appointed attorney, and that has been granted.
Okay. So you will have the public defender as your attorney in this matter. Bond was set in the amount of $50,000 as cash or surety. Do you wish to address bond?
Your Honor, thank you. In speaking with Ms. Shrout, she self-surrendered when she was made aware of this charge. I believe willingness to comply and surrender when she was informed. There's a willingness to cooperate in this matter. I'd ask the court to consider that in this situation and amending bond.
I believe it was a jury trial date that was called in for that you missed. So we're going to leave that at $50,000 cash or surety. We'll get to the, you'll be able to get to the bottom of this. What's that, ma'am?
I'm going to lose everything.
Ma'am, you missed a jury trial date. They probably had 100 civilians come in to sit and be a potential juror for you. Ma'am, you can talk to your attorney about it, but bond, absconding on bond is one of the things you get a high bond for.
But I
You already have next court dates. April 10th is your probable cause conference. April 15th is your preliminary hearing. That's in courtroom B in front of Judge Belargin. You will get copies of those dates and times. You must show up for those dates and times.
I
You're
will
all set.
because I'll be here, right?
Unless you make the bond, yes, ma'am. That's why on absconding, we set a high bond, because if we didn't know where you were at before, we know where you're at
I
now.
did it. I didn't abscond. I called.
Ma'am, don't say anything else in regards to the jury trial date.
Okay.
That would relate directly to the absconding charge.
You're all
I
set.
didn't.
You can ask for a different bond every time you're up in front of a judge. So that very next court date, you can ask for a different bond.
I can, but that's on the 10th.
Right.
So I'm in here till the 10th.
Unless you make bond.
Nobody's gonna pay $5,000 to get me out. We can't afford it. I'm gonna lose my home and everything.
You're all
now.
set, ma'am.
Okay, have a seat.
Hello, Your Honor.
Good afternoon. Your name?
Nicole Newman.
Ms. Newman, this is a felony file 250908FY. I'm going to read it to you.
Good afternoon. Assistant Public Defender Darius here, appearing on behalf of Ms. Newman for the limited purpose of arraignment. We've reviewed this felony file. We waive reading at this time. She's asking that the matter is set for probable cause in prelim. She was screened for court-appointed attorney. That has been granted.
So, ma'am, you will have the public defender as your attorney for the remainder of this case. Do you wish to argue bond?
Hey, Your Honor, thank you. And speaking with Ms. Newman, this matter is about 2 months old at this point in time. I understand there's already been an investigation completed by CPS, and that has allowed the minor listed to return to the home. I'm asking the court to consider pretrial release at this point in time. Ms. Newman has also been in contact and cooperative in that CPS process. We'd ask the court to release her on PR at this point in time.
All right. So that is possible. I just want to get some clarifying matters. First of all, and ma'am, instead of you answering, we'll let your attorney answer unless he doesn't know the answer. I'm not inclined to do a protective condition of bond on this because the victim is a minor and you are a parental figure. So I'm not going to order a no contact. I know that Mr. Sierra, you had mentioned the CPS case was open. Is there an ongoing CPS involvement?
My understanding in speaking with Ms. Newman is that that portion has been closed and allowed the minor child to return to the home with the knowledge that she would be there.
So I'm going to set this at $1,000 PR bond, ma'am. In other words, you are going to get out, all right, of jail in between your court dates. It also sounds like you're going to be back with the victim in this case. So what I'm just writing is no assaultive contact with the victim. So in other words, you can live together and do all the things that people normally do, but nothing along the lines of assaultive behavior. Does that make sense to you?
Yes, sir.
All right. So you already have next court dates. You have April 10 as a probable cause conference. You have April 15th as a preliminary hearing. That's in courtroom D in front of Judge Pelargian. You will get copies of those dates and times. You must show up with those dates and times.
Okay.
Other than that, you're all set.
Thank you.
Thank you very much.
All set.
Thank you.
All right. Thank you.
I need my Zoom up, but not my BIS. Might want to give them a minute. Oh. All set. All right. Well,
Yeah, he's in jail. Does he just not have an attorney yet, or is he not
No, he,
asking for one?
correct. I asked him for a standby, encouraged as much as possible. He wishes to represent himself. So, would you like a breakout room?
Yeah, please.
Okay, after we get Ms. Claxton back. I'm sorry, Mr. Lee, but I think we'll be seeing Mr. Gothier next.
That's okay.
Good afternoon. Are you Noah Gothier?
I am.
Mr. Gothier, we're on the record in case number 25-4109 FY. You're appearing for a probable cause conference this afternoon. You are here representing yourself, and that is still your wish as far as proceeding with this case is to represent yourself. Is that correct?
Yes.
Okay, so we have Ms. Roberts here from the prosecutor's office. A probable cause conference is a time that you are able to have meaningful discussions with regard to a possible plea agreement with the prosecutor's office. Ms. Roberts, you have an offer in this case?
We do, Your Honor. If the defendant pleads guilty to attempted domestic violence, third offense, we will dismiss count 1, which is the domestic violence third, and count 2, which is felonious assault.
So that is something that you should take into consideration and decide how it is that you wish to proceed, Mr. Gothier. You are currently scheduled for a preliminary examination, and for right now, are you intending on holding that preliminary examination?
Yes. I need some time to consider the plea deal.
Well, you'll have until next week at the time that the preliminary examination is currently scheduled.
And can you repeat the plea deal for me? I just want to make sure that I heard it correctly. The plea offer.
So if you plead to an attempted domestic violence third offense, which is still a felony, it's a 2.5-year maximum, then we'll dismiss everything else.
So if the preliminary examination is held, Ms. Roberts, how many witnesses for the people?
2, Your Honor.
And do you intend on calling any witnesses, Mr. Gothier?
I don't have any witnesses to call other than the witnesses which will be called.
Okay. And for the people, Ms. Roberts, do you have information regarding bond?
Was the bond already set?
Yes, ma'am. Bond was set at a 10,000 cash or surety with conditions.
Okay, that's what I was looking at. Thank you. Certainly given one, the fact that this is a felony, but I think the other concern is where this happened was his residence. And certainly he wouldn't be allowed to return there. So I would have some concern if he were to be released, where he would go. I don't want him to be set up for failure, but he certainly wouldn't be able to return to that address. I would note that this is an actual 1, 2, 3, 4, 5th domestic. So that is also a concern as well. Thank you.
Mr. Gothier, is there information you would like the court to know regarding your bond?
Just that it's inaffordable for me at this time, and I don't think anyone else is going to be able to pay it.
At the time of setting the bond, the court's concerns and information were that you have a history of violent convictions. You have a history of failing to appear. Certainly that's of great concern. The safety of the alleged victim. So all of those, for all of those reasons, the bond was set at that amount, and I believe that it's still an appropriate bond to ensure your appearance. Again, you have a known history of failing to appear to protect the named victim in light of your history of violent convictions in the past. So the bond will be continued. The preliminary examination will be scheduled to be held at the time that it's currently scheduled. And so in the meantime, you have the plea offer, and I think that the prosecutor's office can get that over to the jail. So you can see that in writing as well. And do you have anything further, Mr. Gothier?
I suppose I'm underprepared. No, I don't.
Okay. And once again, the court will urge that you consider having a standby attorney, that you would still be on the record representing yourself, but you would have an attorney with you who could provide you with guidance, who could provide you with information necessary to be compliant with court rules, for instance, and how it is that you would proceed at the preliminary examination and other court processes. Are you certain that you don't want a court-appointed attorney?
Honestly, I feel that it would be a waste of public resources and that the resolution of this case would not be changed with a public defendant.
So your answer is no.
I will continue to consider it, but I'm fairly certain that the conclusion would not be heavily affected by an attorney in my favor.
Okay, well, if you do wish to have that standby attorney, you need to let the court know as quickly as possible. The attorney, in order to properly give you advice, would need to have an understanding of the case. So you would need to give that attorney the ability to get that information and then be prepared to assist you even on a standby basis, okay? So please consider that as quickly as possible. Otherwise, for right now, the bond will be continued and you are all set.
All right, thank you. Have a good day.
You as well. Thank you, Ms. Roberts.
Thank you.